So now we're going to move on to the second part of today's program, which is on some of the practical questions on procedure mostly. When I was a student, I saw like there was I don't know, I can't remember which book, but there was this like a flow chart kind of thing where it's supposed to show you where to go for appeal, and I just got so lost.
I'm telling you, I get lost in those too. I've got to write it out, you know.
Yeah, I
So I
mean,
look at the charts and then I make my own chart in my own notes,
yeah.
how it works. Yeah.
So how do you know which court to go for appeal? I mean, I thought that everything goes to the Court of Appeal, but you're telling me no, right? Not everything goes to the Court of Appeal. Because I heard there's something called divisional court. What is that? Like,
Okay,
what is
so just
divisional
let me
court?
give you an example from the doctor's case that I mentioned earlier.
Okay,
So we already know, we've discussed, if you get a decision at the trial level at the Superior Court in Ontario, then you appeal to the
right.
Court of Appeal.
Yes.
Right. So there are other situations where you appeal to the Divisional Court. Now, under the Regulated Health Professions Act in Ontario,
Yeah.
health professionals who are subject to tribunal proceedings within their colleges, so that's like the trial level within a college, so to speak.
Right.
So they have a statutory right to appeal a decision of a tribunal. So in the case of
Okay.
in my physician client, the tribunal had revoked his license. So he wanted to appeal that, and he has a right of appeal within the legislation. So the legislation says, if you want to appeal this, you have to go to the divisional court.
Okay.
Okay. So there is actually an appeal. It's not to the Court of Appeal. It is instead to the divisional court, and that is established under legislation. So
Mm-hmm.
that's where a situation arises where you would go to the divisional court on appeal as opposed to the Court of Appeal.
But after the divisional court, if you don't like it, do you then go to Supreme Court of Canada?
No. If you don't like the result of the divisional court through
Yeah.
this process I just described, then
Yeah.
you have to apply for leave to appeal to the Ontario court.
Okay, to the
So
Ontario
you see, the
Court of
basic
Appeal.
rule that operates in our system is you get one appeal from an original decision. If you want
Okay.
a second appeal, you have to apply for leave. So in this case, we've got an original decision at a tribunal. You have the
Right.
right of appeal to the divisional court, but if you
Right.
want a second right of appeal, you have to seek permission to get that. Right.
Clear.
So this is how it works. So we talked before. So if you've got a decision at the trial court
Right.
that you don't like, you have an
Right.
automatic right of appeal to the Court of Appeal. That's your first appeal. But if
Right.
you want a second appeal, which takes you to the Supreme Court, you
Right.
have to apply for leave. So the
Okay.
basic rule in our system here in Ontario is that you get one automatic right of appeal in most cases. If you
Yeah.
want a second appeal, whether it's still within Ontario or it goes federally to the Supreme Court, you have to apply for leave. So that
Oh,
means you have to make a special, you bring a motion or make an application, depending on the procedures you're under, and you have to persuade the court that it should hear the appeal. So, which is a little different than just making your case. What you've got to make the case for errors of fact, errors of law. You want to make the case that should the original case stand, that it would be contrary to the public interest, that it might create problems that were not foreseen, that go
mhm.
beyond what the parties are experiencing. In other words, it might set a precedent that would be harmful to others. And so you can make a range of arguments there, but you're not strictly making the argument that this case is wrongly decided. You kind of want to show the court, and particularly the Supreme Court, that the issues are serious and they have implications for the rest of society.
Okay, yeah. So up there at that level, but let's go down a few levels now to reality to
Okay.
most people.
Okay.
So I'm thinking about landlord tenant. Let's, for example, landlord tenant tribunal. Just a regular yeah, the admin. And you don't like the decision at the tribunal. You get a right of appeal to the next level, which I guess depending on the legislation, is it probably going to be divisional court? In my
Yes.
case.
So first of all, this gets a little more complicated
Oh,
because so
okay.
if when we start talking about administrative bodies that are established by the state, like
Yeah.
the health colleges, like the
Yeah.
landlord tenant board, like the
Yeah.
Ontario Municipal Board, and so on, we have all of these regulatory bodies in
Yeah.
Ontario, right?
Yeah.
And they are established by legislation, so
Right.
they are public bodies. They're in effect governmental bodies.
Right.
And the divisional court exists for the most part to address the issues that are that arise within one of these administrative bodies.
Oh,
So the
okay.
divisional court is kind of like the public law court of the province.
Okay.
And it deals with, the issues that arise in administrative law and constitutional law for the most part. There are exceptions, but for the most part.
Okay.
So there are two ways you could get from the landlord and tenant to tribunal, whatever it's called here in Ontario.
Yeah.
So you don't like what the tribunal has decided. You have to take a look, first of all, to see whether you've got a statutory right of appeal. Okay.
Right.
If you don't have a statutory right of appeal, what is your option?
Right.
Well, then you apply for a different kind of review of the decision of the administrative body, and that is called judicial review.
Yes.
Right.
Okay. Yeah. Law school's coming back.
Okay.
Okay.
And
Judicial review. That's right.
Right. So that allows you to appeal the decision of any administrative body. It's not an appeal. It allows you to take the decision of an administrative body to the Divisional Court in Ontario to ask for a review of the decision. But the standards are lower than they are for an appeal. Okay. So on a judicial review application, so in this case, landlord-tenant,
Yes.
the divisional court will primarily be concerned with issues relating to procedural fairness. Were both sides heard properly? Did each side get an opportunity to make the full case? Were they able to make all the written submissions and oral submissions that were relevant? Okay. Was there any bias in the proceeding that may have interfered with a just result? On the principles of judicial review, the court can also look for violations of the charter. In fact, there are a whole range of things that the court can look for on judicial review, and they're laid out in a Supreme Court case called Canada v. Vavilov. It was decided at the Supreme Court in 2019. It's 2019 SCC 65, for those who want to look it up. It's a case that essentially revamps the entire administrative law of the country. It's quite amazing. And so there's some new principles that you can avail yourself of on judicial review that are disclosed by that case. So that decreases the deference that is shown to the administrative tribunal. So that's a more complicated situation that probably deserves a separate video. But right. So our most basic point here today is that right. If you seek judicial review, right. The court will primarily be concerned with issues of procedural fairness, okay. And whether there has been a charter violation. But great deference will be shown to the finding of fact of the tribunal, more deference than an appeal. And great deference will also be shown to the findings around the law, right? And so the divisional court will allow the tribunal to reach a range of reasonable outcomes in relation to the determination and application of the law, whether it's statute law or common law. So you see, on judicial review, you just can't go like rushing in like you can on appeal and say, the decision maker applied the wrong case, or didn't read the case properly, or ignored a case, or whatever, and it led to a result that should not have occurred. You can't do that on judicial review. Okay, so the error of law has to be like very, very egregious and significant before the court will intervene.
I asked that question just now, and I feel like I opened a huge can of worms or something. But
right, I'm sorry, I sort of opened up those worms myself. I've been trying to stuff them back in. I hope I've done.
Right, yeah, because it's funny because I wasn't even thinking about judicial review, and now you're like, oh, but that's so interesting indeed. A very practical question now. Mm-hmm. Given that that the path to appeal, it can be a little bit confusing. Like, what happens if you're a new lawyer and you started your appeal at the wrong court, or you didn't go to the right court? Would the court clerk tell you? Or I guess not, right? Like, what happens like if you
sometimes I think sometimes the clerks will send things back to you and say, occasionally they will say, hey,
this is the wrong.
I haven't had that happen to me. You're in the wrong court, but they might say, oh, there's something about the filing that doesn't meet our requirements. They'll send it back to you and say, can you correct this? Right. So there is some communication, but don't count on it.
Because I've actually heard from some peers, of some colleagues that had happened to them, that
Okay.
they've gone to the wrong court and then somehow and because you know how sometimes you file at a certain court and then you wait and wait and wait for the
Right.
hearing.
Oh,
And
yeah.
then when the hearing finally comes 2 years later or whatever, then you find out you're the wrong court.
Right.
So does that happen? What happens there? I guess
Well, I've never heard of that happening.
I heard of that.
Because like the other side would pretty quickly object once they got your
Oh,
statement of claim,
yeah.
they or whatever
The notice
the
of
notice of
appeal.
application,
Yeah,
whatever the originating process is.
right.
The other side will say, hey, this guy's in the wrong court. And so we're not going to
Okay.
deal
They
with
would.
that. So
Oh,
you'll find out from the other side pretty quickly. Like the
okay.
court doesn't even have to intervene. It will just naturally unfold. Okay. But there is, if you make a mistake that way, assuming that you're within the timeline, say with a statement of claim, the statement of claim, you have to be strictly within 2 years since the cause of action
Yeah,
arose.
limitation period.
Right? So
Yes.
2 year limitation period. And so what if you send the statement of claim to the wrong court? I can't imagine how that would be possible, but let's say that you do that. It occurs, or you learn after the 2 year period. Right?
Well,
So
it's not so much.
let's say, I'm just trying to get this right. Let's say you've got the statement of claim, you put it in, you file it in month 23, and then
Yes.
you learn in month 25 that you filed in the wrong place or you filed the wrong one. Okay.
Yeah.
You can apply to have that remedy because the rules are not quite as strict as you might think. Because
Oh,
there's a basic principle of interpretation,
yeah.
and it's established in Rule 1.04 under the Rules of Civil Procedure. And it says that the rule should be given a liberal interpretation to secure the just, most expeditious, and least expensive determination of the issues in the proceeding. And so that basic principle of interpretation gives you some wiggle room. So let's go back to the situation where you filed with the wrong court. Under Rule 3.02 sub 1, you can apply to extend the time or change the time, right? And so there is actually an explicit remedy under this rule for a situation where this kind of mistake arises. So you can apply for an extension of time as long as you can make a reasonable case for the mistake, and the other side is not unduly prejudiced.
Let's say that you've gone to trial, you've got a decision, you don't like it, and you mistakenly appeal to the divisional court.
Right.
So are you completely done? Are you cooked?
No, I think so the problem would be that you would pass the timeline. You
Also,
might find out, like,
right.
if you're still within the filing timeline, right, whether it's
Yeah.
15, 30 days or whatever it may
Yeah,
be,
yeah,
right?
right.
So if you find out on, day 10, you've made a mistake, you just refile quickly, you're still within the timeline. No harm, no foul. But it's when you've passed the timeline for filing
Yeah, then
in
you're
the
in trouble.
rules, then you have to go back to Rule 3.02 sub 1 and ask
Perfect.
for an extension of time and make your case for it.
That makes sense. Okay, so we're moving on to this slide I have that's called Can You Appeal? Can you appeal a decision if you feel that the judge ignored, oh, maybe you answered this already, the judge ignored facts that you presented?
Right. So this would go on appeal if you say the judge ignored key facts. This takes us back to the argument about palpable and overriding error.
Right.
So you have to prove that it's clear on the face of the record, so to speak, that the judge ignored these things. And ignoring those facts led to an overriding error. So in other words, they were material to the result, or they were crucial to the result. And if those facts had been properly assessed and considered, a different result would have been reached. So you've got to make that case in order to have the finding of fact addressed on appeal.
I think we touched on this earlier with bias. Yeah, because like I think a lot of it's very natural to kind of think that when you lose at a trial, it almost very often feels like the judge was biased against you.
Mhm.
So can you appeal to, can you make an appeal because you feel that the judge was biased?
Absolutely, you can.
Mm,
Absolutely. So there's a basic principle here. It's called the reasonable apprehension of bias.
right.
You can argue that comments made by the judge or certain other kinds of conduct indicated a bias in favor of one side or another. And this does happen. There have been some notable cases with this recently, but the court in assessing bias begins with the presumption that courts act with impartiality. So the presumption is really in favor of impartial conduct on the part of judges.
Right,
So the burden is upon you, to make
right.
the case that bias existed. And the bias, generally, if bias is found, the entire decision is scuttled. But the bias has to be significant. So, yeah, bias generally, a finding of bias generally leads to an overturning of the entire decision.
Yes.
But I just qualify that because there might be gradations of bias.
Of course, yes.
That's more a practical consideration, actually, I think, than a legal.
Yeah.
So,
Well, I
so
can
yes, I
imagine,
mean,
yeah,
just let me put it this way: if you think you have clear evidence that the judge made statements that clearly favored one side over another,
yeah.
then you probably have a strong case.
Well, that's interesting. So for example, I'm probably not going to include this part, but I'm just thinking, like, let's say when your witnesses go on the stand, the you feel that the judge is always kind of like uh either supporting the witness, but then when the other, okay, sorry, I should reverse, like if the opponent's witnesses seem to get a favorable treatment from the judge, but your witnesses are constantly kind of like put down or whatever, you can kind of use that
Oh,
as
yeah, yeah. So for
evidence.
instance, when, the judges will make rulings on what kind
Yeah,
of questions and you can ask and what kind of comments you can make
right.
while right, while you're examining or cross-examining witnesses.
Yeah,
And so let's say I'm cross-examining the witness for the other side,
yeah,
and the other side objects to certain questions that I ask. And I feel that as a matter of law, I should be able to ask those questions. But
yeah,
the judge consistently rules against me. Right.
yeah,
And it becomes a very clear pattern. Whereas when I make objections to
yes,
the cross-examination of my witnesses, the court is very, very liberal
yes,
and doesn't really deal with my objections.
yeah. They keep
So,
overruling yours.
right. And so that could lead to appeal based on an error of law, like misapplying rules
Oh,
relating to evidence.
right,
So that, but you could also, if it's a consistent pattern, can make the case that it's also bias.
right. Right. But so this is so you would include in your transcript, yeah, you would just probably cite all those passages in the
Oh, yeah.
in the transcript into your argument, I suppose.
That's right. That's right. So in
Oh,
your factum,
yes.
that you would lay out,
Layout, yeah.
in the
Right.
fact section of the factum, right,
Okay,
which is
right,
the first part. You
right.
would rely on these things. The judge said this, didn't say this, said that, didn't say that. You lay that all out.
Yeah,
Right?
yeah, yeah.
And then in the section where you're dealing with the law, you would apply the law to that fact situation that you've described and say, this is clearly evidence of bias and so on.
If you did win a trial, but you didn't like the amount awarded to you, you didn't like the quantum.
Mhm.
As the winner, can you appeal?
Yes, you can appeal on quantum,
Oh,
sure.
oh, even though you won, like, so you can still
Right. So you can argue, damages are part of the law. So
right,
there's a whole body of law on damages
right.
and what amount and kind of damages are appropriate in given situations. So if your client you felt deserved 2.5 million, but only got 250,000, then
Yes.
you could appeal that on the ground that the court didn't make a
Oh.
proper determination of the law relating to damages.